Good afternoon, everybody. My name is Steve Rohde. I'm a former president of the Beverly Hills Bar Association and on the executive committee of Out of Court, one of our BHBA programs that presents a series of seminars and these days webinars. I'm really grateful that each of you are here. We've had an extraordinary registration rate, and a lot of people are so interested in this unprecedented election in the midst of an unprecedented year. We've been able to bring two experts into this discussion, whom I'll be introducing in a moment. We've got a tremendous amount of material to cover. This program was conceived of a few months ago, and every time we planned what we were going to talk about, it kept changing due to breaking news. And that's been no different right up until yesterday as we discussed what's happening in the US Supreme Court. Because we're covering so much material, we'll have a limited time for Q&A. I'd encourage you to put any questions in the chat box primarily. If necessary, you can use the Q&A feature. I'd prefer the chat, which I'll try to curate toward the end of the program. We'll be talking with our guests up until 1:30 California time. You know, it's a wonderful pleasure when you've been practicing law a while and been involved in various organizations to be able to call on friends who are not just friends, but experts in their field. We're joined today by Richard Hazen. He's the CNN election law analyst and Chancellor's Professor of Law and Political Science at the University of California, Irvine School of Law, has published widely. I just heard a few moments ago he's in the midst of writing a new book, and we're very grateful to have you with us. As I know him, Rick Hazen. Thank you for joining us.
Great to be with you.
We're also joined by Erwin Chemerinsky, who I've known personally and professionally for over 25 years. Erwin is Dean and Jesse H. Chopper Distinguished Professor of Law, University of California, Berkeley School of Law. Welcome, Erwin.
It's a pleasure to be with you and Rick.
We're co-sponsored today through the auspices of UC Irvine School of Law and Berkeley School of Law, and I understand many law students are joining us on the program today to watch and participate. It's remarkable that this election had a record turnout of 66.7% of registered voters voted, the highest percentage since 1900. There's also been polling that 94% of people found that voting was easier in 2020 in the midst of this pandemic. Yet it is an unprecedented election in terms of the resistance of Donald Trump as President of the United States to accept the certified results of this election. And it is in that nature that we'll be discussing these issues today. We're going to begin with Professor Hazen in a series of questions catching us up on the litigation that has been pending throughout this election period. And I'll be asking a series of questions about that. Professor Chemerinsky, Dean Chemerinsky, will join us in that conversation. And then I'll be turning to Erwin to look at the Electoral College, these key dates that are coming up this week and next week, what the prospects are. And then finally, has this election been helpful or hurtful to American democracy, and what kinds of reforms may we begin to look at to deal with what we've been through. Rick, would you just briefly, because I hear there's over 30 lawsuits that have been filed in state and federal court, but try to give us an overview of those cases, gather them in any categories you see fit, and give us a sense of what this election period from a litigation standpoint has been like.
Sure. It's great to be with you and to join you and Erwin and the Bar Association again for an event like this. Maybe next time we'll be able to do it in person, which would be nice. So just going back to before the election, we've been seeing a rise in the amount of election litigation. I've been tracking it for decades, and we have triple the amount of election litigation in the post-2000 period compared to the pre-2000 period. 2018 was already a record for election litigation before the pandemic, which was remarkable because usually I saw dips during the midterm elections in litigation, but yet 2018 was so litigious. And 2020 is for sure going to break the record when I finally put all the numbers together. The coronavirus is a big part of it. Some states made changes in election rules in response to the pandemic that prompted lawsuits. Other states didn't make changes in their election rules, and that too prompted lawsuits. There was no way to avoid a lawsuit. Just about every state saw multiple lawsuits. And some of those lawsuits in the pre-election period came back to bite in the post-election period. And so now, for example, we're seeing cases, and I think we'll talk about this more in detail later, where the state Supreme Court in Pennsylvania made a change to a deadline before the election, and that now plays into post-election litigation. Let me talk just very generally about the kinds of post-election litigation we've seen. First of all, we've seen kind of standard election contests. When you have a really close election, someone can, and I'm only talking about the presidential election, not for other elections. When you have a really close election, someone can file an election contest, or they can administratively seek a recount. We've seen the Trump campaign do both of those. They sought recounts in Georgia. They filed an election contest, which is being heard as we speak right now in Wisconsin. That's kind of a traditional kind of lawsuit filed in state court. Very hard to win those because you have to show either that the election was so close and you can flip a few votes and change the results of the election, think Bush versus Gore 20 years ago, or you have to show massive irregularities in the votes such that we think the election was not fairly conducted. And those lawsuits almost all failed. We also saw the Trump campaign and the Republican Party filing suit in federal court, claiming that certain rules that were used during the election or certain procedures that were followed or potentially fraud in the election created a federal constitutional claim. All of those lawsuits have failed as well. And we've also seen outside groups and individuals supporting Trump file lawsuits, the so-called Kraken litigation, but brought by Sidney Powell with some outlandish claims of fraud. And so generally what I can say, and I'll end with this in the general overview, is the Trump campaign and their allies have won only one case out of about 52 that have been decided so far. And that case involved a very small issue. There's one potential issue pending in the United States Supreme Court that would not be enough to change the outcome of the election. But in all of these cases, there has been no proven evidence of widespread fraud. There's been no proof of any irregularities. There have been no elections that are close enough that you could plausibly try to change the outcome of the election. And so, that's kind of the general view of what we've seen so far.
Thank you, Rick. Let's focus on the Supreme Court, both in what it has done and has before it. There was the case of Mike Kelly versus Pennsylvania that got a lot of attention. Please give us an overview on that.
Yeah, so Pennsylvania has seen a number of lawsuits, or Pennsylvania has seen itself as the defendant in 3 lawsuits at the Supreme Court. And I think it might make sense to talk about the 3 of them together,
Good.
because they are somewhat related. So why Pennsylvania? Pennsylvania, battleground state, history of problems with the election administration. They've got a Democratic Secretary of State. They've got a Democratic governor. They've got a Republican legislature. They've got a Democratic dominated Supreme Court. And so it's a place rife for controversy. It's got a lot of electoral college votes. It's got 20 votes, so it matters a lot, for the outcome of the election. And so there were a number of changes that were made in response to the coronavirus that involved how mail-in ballots were treated, not just Pennsylvania, but everywhere. We've seen a real rise in the number of absentee ballots that were used. One of the lawsuits that happened before the election involved those rules for counting absentee ballots. And among other things, the state Supreme Court ruled that under the state constitution, given the pandemic, ending the election, the receipt of ballots on election night was unconstitutional. And under the state constitution, they extended that for 3 extra days. They also made some other rulings about whether ballots could be corrected if there were errors, and lots of small rulings along the way. And so this has prompted 3 lawsuits at the court. One lawsuit, and it makes sense to talk about this lawsuit brought by the Republican Party before I talk about Kelly. One lawsuit argued that when the state Supreme Court made changes to its deadline for the receipt of absentee ballots, it was violating the rights of the state legislature. The Constitution provides that state legislatures get to set the rules for picking electors and get to set the rules for congressional elections, that one subject to congressional override, and that when a state Supreme Court relies on a state constitution to extend a deadline or to take an action, that violates the so-called electors clause in the Constitution. This is a claim that was raised in 2 emergency petitions that went to the Supreme Court in this Gore case, the Scarnati case. And 3 or 4 justices, depending on how you count, expressed some interest in the legal issue as to the scope of what state courts can do in applying state constitutions against state legislatures. But the court declined to get involved, did not issue an emergency injunction. That case is still pending. There's the possibility of the court hearing that even after the election to resolve that issue. That case only involved 10,000 ballots. Those ballots were not included in the federal totals, and they would not affect the outcome of the election. In the Kelly case, which you mentioned, which was just decided earlier this week, Representative Kelly, who's filing on his own, he made an argument that was kind of the flip side of this, that the state legislature somehow violated its own obligations under the law by not following the rules in the state constitution, which would have prevented it from adopting absentee balloting at all. It was kind of a bizarre theory. It's even hard for me to explain. It kind of flips the independent state legislature doctrine that was raised in that first case, Bukvar, on its head. Really strange case. The Supreme Court, and Trump was trumpeting this case, saying it was going to be a big deal. The Supreme Court summarily declined to address that case on an emergency basis. That case is all but dead. A cert petition could be filed. It wouldn't be ruled on before the election, so that case is not going anywhere. And then there's the third case, which is the Texas case. I don't know if you want me to pause here and see if Erwin wants to add something, and then I can talk about the Texas case, which also challenges Pennsylvania as well as 3 other states in how they conducted their election.
Yeah, let's pause. Yeah, we'll pause and we'll turn to the Texas case in a moment. But I wanted to unpack for everyone this doctrine of independent state legislative. And there were justices on the Supreme Court that wrote on this. And a lot of people were worried whether they could gather a majority on this doctrine. So, Rick, if you would unpack that first, and then I'm eager for Erwin's views on all this.
Right. So this issue actually echoes something that came up in Bush versus Gore 20 years ago. You may remember in Bush versus Gore, the Supreme Court stopped a recount in Florida that the Florida State Supreme Court had ordered. The main theory as to why they did that was that there was an equal protection violation in treating some voters' ballots differently than others. But there were 3 justices in a concurring opinion by Chief Justice Rehnquist, joined by Justices Scalia and Thomas, who said that when the state Supreme Court enacted its recount rules, it violated the right of the state legislature to set those rules. And it was very controversial then. It was never adopted by the Supreme Court as a majority decision. And it would be kind of odd to state that a state Supreme Court could not even apply its own state constitution in deciding what the rules are for conducting state and federal elections. But you're right that in a couple of cases, one of them, the one I mentioned, that first case filed by the Republican Party that went to the Supreme Court, as well as in a concurring opinion in a North Carolina case, where Justice Kavanaugh wrote a concurring opinion, you had Kavanaugh, Alito, Gorsuch, and Thomas all suggesting a very strong version of this independent state legislature doctrine, and the possibility that they would believe that you can't, that state courts and state agencies and state executives are limited in deviating from the rules that state legislatures set, even in the context of elections that are being run for state and federal office. Maybe Justice Barrett would agree with that as well. We know that Chief Justice Roberts expressed some skepticism about it, but with Barrett, that would be 5 justices. But Justice Kavanaugh suggested, and also in one of these cases, that even if the independent state legislature doctrine might have been violated, it's too late to make a change now. You can't retroactively disenfranchise voters. And so I never thought there was a really serious threat that this issue could threaten to overturn the results of the election in any state, even if the election were closer. But it is a looming issue out there, and I think it's going to have to be resolved before 2024 because these issues are not going away.
Thank you. Erwin, on this whole collection of the previous litigation, the Supreme Court up until Texas, what is your take on all this?
I obviously agree with Rick. I don't see any of the litigation as changing the outcome of the 2020 election. But as he was just saying, I'm troubled by what some of these doctrines are going to mean for the future. The independent state legislature doctrine is one of these. If it were to become the law, then state courts couldn't protect the right to vote by interpreting the state constitution. State election officials could not protect the right to vote. It would take the word legislature literally. Now, in 2015, the Supreme Court rejected that approach, but it's a different court now. And I would pair this with something else that we saw that the Supreme Court has done, and something that Rick has written extensively about, the fact that the Supreme Court has said that federal courts can't change the rules of an election soon before the election, even to protect the right to vote. This comes from a Supreme Court case, Purcell versus Gonzalez, from over a decade ago. Rick, I think you're the one who coined the phrase, the Purcell principle. If you go back and read Purcell, it was per curiam opinion. It wasn't after briefing and oral argument. It wasn't a principle or a rule of this sort, but it's certainly in 2020 been treated by the Supreme Court that way, and it has since Purcell. But the reason I bring this up here is the independent state legislative doctrine says that state courts can't protect the right to vote. The Purcell principle says federal courts before the election can't protect the right to vote. And to me, for the future, the combination of those is very troubling. Because if the courts can't protect the right to vote, who will be there to do that?
Staying on this for a moment, Rick, when you say this is going to need to be clarified, the doctrine relies on a provision in the U.S. Constitution. Would this take a constitutional amendment, or would it be addressed through litigation?
So that Pennsylvania Republican Party case, it's possible that the court would review it on grounds that, the exception to the mootness doctrine is capable of repetition, yet evading review, because it's very hard to litigate these things in the middle of an election when you know what the stakes are. So it's possible that the court would agree to hear the case anyway. Even if it doesn't, I'm sure there are going to be other cases that are going to be filed around the midterm elections where someone's not going to like a rule that a state court has put in place. Typically, we're talking about patterns of state Supreme Courts dominated by Democrats expanding voting rights against a Republican state legislature. So that's like state like Pennsylvania, North Carolina. So it could come back. And so I think, we don't know exactly what the court would say if it actually had full briefing on this question. And it would raise all kinds of knotty questions about, how far a state court can go in interpreting. What if a state court interprets a state statute in a way that someone believes, well, that wasn't really interpreting the statute, that was really legislating from the bench? Is the Supreme Court going to get involved in litigating all of these from state Supreme Courts? It would get very messy. But I think Erwin's right that if you put the Purcell principle, as well as the cases that came out where the court said that federal courts should generally defer to states about how to balance health and safety concerns against voting, with a strong view of the independent state legislature doctrine, then there really would be no check on what state legislatures do in setting out the rules for conducting elections that include federal candidates.
Erwin, for a lot of our viewers, there's a core principle of independent state rulings and insulating review of state constitutions and state law by the highest court of each state from federal review. Does this begin to encroach on that and question those principles of federalism?
The principle is that if a state court decision rests on an independent and adequate state ground, then the Supreme Court won't review it. In other words, if you have, say, two grounds of decision, one federal law and one state law, if Supreme Court reversal of the federal law ground won't change the outcome, the Supreme Court can't hear it. So long as the state court decision is resting on state law that's truly independent of federal law and is adequate to support the result, there can't be Supreme Court review. But if there is a federal constitutional challenge to that state law ground, then the Supreme Court can hear it. What they're reviewing isn't the state law decision on state law, but what they're reviewing is whether the state law violates the US Constitution or federal law.
That's very helpful. Well, this seminar might have ended now, but a few days ago, a brand new lawsuit was filed. This is the case, everybody. We're having questions about this already in the chat. Filed by the Texas Attorney General, Ken Paxton, in the name of the state of Texas, suing the states of Pennsylvania, Georgia, Michigan, and Wisconsin. The case has been endorsed by 17 other Republican state attorneys general. President Trump is seeking to intervene. Republicans in the House are circulating the opportunity for an amicus brief. And if there wasn't such breaking news, about 2 hours ago, further briefs were filed in this case. Beginning with you, Rick, what, if you can give an objective summary of this case to begin with, what is it all about? And what are the issues and what's your view of the prospects of that case?
All right, so this is very unusual. You have the state of Texas suing 4 other states. That would be Pennsylvania, Georgia, Wisconsin, and Michigan, arguing that they conducted their elections in such an improper way that the Supreme Court should throw out the votes of millions of voters in those 4 states and instead let the state legislatures choose the electors. Now, why those 4 states? Those are 4 states that voted for Biden. Throwing out those votes and letting the state legislatures choose would flip the election to Trump. All right, so you've heard of the Hail Mary play. This is beyond the Hail Mary play. This is, and now I'm speaking objectively, garbage. It is the worst lawsuit I think I've ever seen filed in an election case before the Supreme Court. And I said that about the Kelly case, but this one really goes well beyond it. The state is trying to, 4 days or 5 days before the electors meet, trying to overturn the results of the election by challenging not how an election was done in Texas, but how an election was done in 4 other states. There are issues about standing. There are issues about mootness because the case has been, in every state they've already certified who the winner is. There are questions about latches. Why do you wait until just the week before the election? There are questions about the merits. There's nothing in the Constitution, and this even goes against the independent state legislature doctrine. And Ohio just filed a brief saying this very thing. They're saying, Texas doesn't get to tell Michigan how they pick their electors. And also, in order to invoke this extraordinary original jurisdiction of the Supreme Court, and this is something I think Erwin can weigh in on better than I can, it's more of a federal courts issue, you've got to show that there's no way to bring these issues to another court. Well, all of these issues have been brought to another court. All of the claims of fraud and mismanagement of the election in every one of those states has been litigated, and in every state's been rejected. It's also based on really shoddy social science evidence, a really bad statistical analysis of how there was a 1 in a quadrillion chance that Joe Biden could have actually fairly won the election. I mean, it's just, I think the best way to understand it is as a PR stunt masquerading as a lawsuit. But unfortunately, 17 other attorneys general have signed on. This has become a political litmus test. While we're speaking, I just got a notice that 106 members of Congress have now filed an amicus brief. This case is being teed up for decision by the Supreme Court as early as tonight or tomorrow. I imagine they'll give time for Texas to file a reply. 22 states and territories just signed on to a brief on the side of the states that have been sued, saying that this is none of Texas's business. So I imagine we'll get something tomorrow, tonight or tomorrow from the Supreme Court. It might be 9-0. It might be 7-2 because there's a procedural wrinkle about whether you can just not grant original jurisdiction or you have to grant original jurisdiction and then dismiss the case. But I don't expect to see any Supreme Court justice buying into this doctrine, which, if you believe in principles of federalism, separation of powers, this is just a really crazy lawsuit. And it's, I think, a national embarrassment that it was filed. I'm sure Erwin is going to say it more calmly than I have.
Yes, go ahead, Erwin.
I think Rick is right. I mean, I think to start with, it's impossible to see how Texas and the states that came in outside are injured. And so therefore, there's no standing, and that should end the inquiry. Also, think about what the remedy here is that's being sought: to not count the electoral results in Pennsylvania, Michigan, Wisconsin, and Georgia. In other words, to disenfranchise all of their voters. Were the Supreme Court to accept that, and were the Supreme Court to effectively give the election to Trump, that's the end of American democracy as we know it. And I can't believe that any of the justices want to go down that path.
Rick, there was I gather a theory that because Vice President-elect Harris will preside over the Senate, Texas was harmed if these results are certified because Texas has senators in the Senate. Is there any other separate theory behind that argument?
I'm going to let Erwin take that because that's a standing question. But let me say before turning it back to Erwin that I forgot to mention one other thing, which is that when you go to the Supreme Court and you make factual allegations in an original lawsuit, the Supreme Court is not set up for fact-finding. They ordinarily, so, they say there's a dispute between two bordering states about, who owns the water in the Colorado River. This court has to appoint a special master to engage in fact-finding. So even if the court wanted to take this case, how are they going to know whether the statistical analysis that's offered there is any good? And they're going to figure this out, and they're going to do this all in 4 days before the electors vote. It's just ludicrous. But I'll let Erwin answer about the standing point about the Senate.
Standing requires that somebody show a concrete and particularized injury. It can't be just speculative. Texas doesn't have a concrete and particularized injury. I think that the current court, with justices so committed to states' rights and federalism, certainly can't accept this lawsuit or do anything with it. Just a year ago, in a case called Rucho versus Common Cause, the United States Supreme Court, 5-4 with the conservatives and the majority, said that federal courts should not get involved in hearing challenges of partisan gerrymandering because federal courts shouldn't become enmeshed in the political process in that way. How could those justices now say that the federal court should be enmeshed in the political process and the Supreme Court should decide the election? It's inconceivable to me.
One of our up-to-date listeners tells us in chat that the Pennsylvania legislature just filed an amicus on the Texas side of the case. This is a supplication. Please sue us, sue us, sue us from the Pennsylvania legislature itself. Any additional thoughts on that, Rick?
Well, I looked before we got online. There may have been something filed since then, but there were two briefs coming from Pennsylvania legislators. One was from a group of independent legislators, and this is no surprise because a bunch of them have already sent a letter to Congress saying that Congress should fight the Electoral College votes when the Electoral College votes are counted on January 6th. The other was from the Speaker of the House and the Majority Leader. These are two people who were pressured by Trump into calling a special session and trying to declare a separate state of electors, which could then set up a fight in Congress over the Electoral College votes, which I know Erwin's going to talk about in a few minutes. In that brief, the one by the state legislature, the Speaker of the House and the Senate Majority Leader, they said, we're writing this brief to tell you about the problems there were in Pennsylvania, but we're not saying anything about whether the remedy is appropriate. So they did not come in and say, yes, we should be sued. I think what they were doing was trying to placate Trump. And in fact, there was an article in the New York Times yesterday, I think it was, where a Pennsylvania legislator, a different legislator, was asked about, would you sign one of these letters? And the legislator responded, if I don't sign one of these letters, I'm worried someone's going to threaten to firebomb my house. And, that sort of fear of real violence. And we've seen threats against Republican and Democratic election administrators, elected officials. It's just terrible. And, it's really tearing at the fabric of American democracy.
I just want to add, we've all spent time thinking about how do really horrible things happen in a society? How can good and decent people watch terrible things occur? And it's because people stand by silently or they're complicit. This election isn't in doubt. The popular vote is over 7 million. Joe Biden has over 300 votes in the Electoral College. And yet what you find is Republican leaders haven't said that. Mitch McConnell is yet to say it's over. Just today, Kevin McCarthy, California, the Republican minority leader in the House, has said it's not over. We've talked about 17 attorney generals filing a brief on the side of Texas. This really undermines democracy in a profound way. Saw an opinion poll that 70% of Republican voters say that there was substantial fraud in the election. In fact, the Donald Trump brief filed yesterday cites that statistic. We shouldn't become inured to this. This shouldn't be the banality of evil. I mean, this is really a threat to democracy in its most basic sense.
So let's grab a hold of that. We're going to come back to the Electoral College in a moment, but this was going to be a subject later, but you framed it so well. Some of the folks are answering your concerns by invoking the hallowed right to file a lawsuit. So all that's happening is people are exercising their constitutional right to file a lawsuit. We must allow justice to play itself out. Erwin?
There's a right to file a non-frivolous lawsuit. There's not a right to file a frivolous one. And I think so many of the lawsuits that Rick described, including this one that's filed by Texas in the Supreme Court, are frivolous. I would say they are sanctionable under the usual standards of Rule 11. There isn't a right there. But beyond that, I think there is also an obligation of elected officials to be faithful to democracy. That this election is clear. And for elected officials like the Senate Majority Leader, the House Minority Leader, to not accept the result, to enable what Donald Trump is doing in this regard, is something that we should really condemn. It's never been seen before in American history.
Erwin, your take on this question of the right to sue, letting the system play itself out versus what's going on today.
Do you mean for me?
Rick, yes.
Yeah. So I think that what the end of the Trump presidency shows is what we've seen throughout the Trump presidency, which is so much of our political system depends upon people complying with norms as opposed to specific rules. So when the media calls the election for a candidate who's won, that's not official, but yet most people abide by it. When that happens, and it's a close election, there's a lawsuit. If the lawsuit fails, the candidate concedes, right? That was Al Gore, who the morning after the Supreme Court decided Bush versus Gore in 2000, conceded to George W. Bush. And so what we see is a president that is using false claims of a fraudulent election as an excuse to try to steal the election, to flip the election results when there's no good evidence that there was any kind of problem that would justify changing the results in even one state, much less in the 3 states he would need to get a different election result. I think we're in for a rocky road going forward because if you're going to have millions of people who don't believe that the election was fair, then what kind of democracy do you have? A democracy depends on the losers believing the election was fair and being willing to fight another day. And no amount of evidence seems to convince some of the most ardent Trump supporters. We'll have to see what happens once Trump is out of office. But it's a really dangerous moment for our democracy. And this is the book I'm writing now, is how just kind of the rise of disinformation and the ability for it to spread so virulently really is a threat to American democracy in a way that we have not seen in the modern age.
We may have time to return to those subjects, but who would have thought that people have written on their calendars December 8, 14, and January 6th, the safe harbor, the meeting of the Electoral College and Congress. Erwin, simply take us through what has happened with the Electoral College so far, what we expect next week, and whether there are any openings for any other mischief as the Electoral College process comes to a close.
The bottom line is, I don't see an avenue for mischief. I think this election is decided. But let me go through each of the steps you mentioned. I'll start with December 8th. This actually goes to a federal law, the Electoral Count Act of 1887. And it says if results are settled by 6 days before the Electoral College is to meet, they're deemed conclusive and the result has to be counted by Congress. And so if states certify their electors by December 8th, that's deemed the electors of the state, and they'll be counted by Congress. This became quite important in Bush versus Gore in 2000, when the safe harbor day was December 12th, and the Supreme Court used that as the basis for ordering an end to the counting of votes in Florida. All 50 states have now certified their electors. This all happened on schedule by December 8th. These states have met the requirements for the safe harbor. December 14th is the 6 days later. It's the day the Electoral College votes. You use the phrase the Electoral College meets, and that's actually a misnomer. The Electoral College never meets as a body. I think the phrase Electoral College connotes a group of people who come together like a college, but it's always that the electors vote in their home states. Even apart from COVID, the electors vote in their states. But it is on December 14th that the states, through their electors, cast the votes in the Electoral College. There's always the possibility that some electors won't follow the dictates of the state. 48 states out of 50, all but Maine and Nebraska, follow winner take all. So the winner of that state's popular vote, however close, get all the electoral votes of the state. Maine and Nebraska divide them up. And there is an issue of, does an elector have the right to vote his or her conscience? Or put another way, what about the faithless elector? Just in June of this year in Chafalo versus Washington, the Supreme Court unanimously said a state can dictate how the electors vote, that a state can fine the electors who don't vote that way, or even like in Colorado, replace the electors who don't vote the way the state dictates. There's still a handful of states that don't dictate how the electors vote, that don't prohibit faithless electors, but it's not likely there's going to be more than a few, if any, faithless electors in this election, so it's not going to make any difference in the outcome. Finally, Steve, in terms of January 6th, Congress will meet in its joint session. There is a procedure where it will go state by state, and the winner of the electoral votes of that state will be announced. A member of the House or the Senate can challenge that. There is then a recess where the House and the Senate meet separately for now when they come together. But it would take agreement of both the House and the Senate to not count the electors from a particular state. And given that the House is Democratic, we know that there's no way they're not going to be willing to count the votes that bring Joe Biden the presidency. So we're past the safe harbor. The Electoral College meets on Monday, and then Congress will certify the outcome on January 6th. And then at noon on January 20th, the president is inaugurated.
There's been some confusion about that question of whether how the House votes on an objection. You mentioned that the House is controlled by Democrats, but viewed by delegation state by state, there are more Republican-controlled House delegations. So in this context, rather than a different context, how does the House vote?
The House votes as it would for anything else. You're speaking of something else. Imagine that neither candidate gets a majority in the Electoral College. Imagine the unthinkable, and the Supreme Court rules in favor of Texas, and the way it plays out is that Pennsylvania, Michigan, Wisconsin, and Georgia don't get votes counted at all in the Electoral College. Then no one would have a majority, and then what would happen would be, if the election goes to the House of Representatives, each state gets one vote in the House of Representatives, and that's determined by the majority delegation in that state, and Republicans then would be able to give the election to Donald Trump. Again, that's far-fetched. It's beyond unlikely.
That's a very important distinction, and I've been getting calls and phone calls and emails of people who confuse those two circumstances. So I'm very grateful that you clarified that. Rick, any views on this next period as it relates to the Electoral College?
I would just point out a few additional things. Number one, the 20th Amendment provides that if there's no choice of a president for some reason, that Donald Trump is no longer president at noon on January 20th. So even if there were some way of deadlocking, it would not extend the Trump presidency. The other thing I'd point out is that in order for there to be an objection, as Erwin mentioned, you'd need the agreement of both a member of the House and a member of the Senate. And it's not clear that we're going to have a senator who's going to agree. We know that there are some House members who are going to object. But I do think it's just going to be more for show, even if there is a senator that joins. And then the last point I'd make is there's a lot of problems with how the Electoral Count Act is written. For example, Erwin said, you know, what if Texas won at the Supreme Court and we took those states out? There's a debate as to what the denominator is and how you determine a majority. Do you remove those states from the denominator or not? And so there are so many problems, and I hope, and this goes a little bit towards the question of reform, I hope that, I'm not optimistic, but I hope that there will be an effort to try to come up with some more sensible rules than the Electoral Count Act for dealing with these kinds of issues. It shouldn't be that everyone is focused on who the Wayne County Canvassing Board member is, you know, who has this ministerial act of deciding to, you know, say that their votes are correct. We shouldn't have so many points where political actors can come in, violate norms, and change election results. We need to have clear rules, both for what Congress does and also what the states do.
Erwin, apparently Joe Biden got upwards of 7 million more votes than Trump. Hillary Clinton got more votes than Trump. We've got this albatross of the Electoral College in the Constitution. Briefly, do you believe it's time under a Biden administration for you to be appointed head of a national commission to explore the Electoral College and decide whether or not a constitutional amendment is appropriate?
The problem is there's no way to get such a constitutional amendment passed. Ratifying a constitutional amendment takes 2/3 of both houses of Congress and then 3/4 of the states. The states that benefit from the Electoral College will never vote for a constitutional amendment to eliminate it. I think the Electoral College is inconsistent with the most basic precepts of democracy. The idea that the person who loses the popular vote can become the president, as happened 5 times in American history, can't be reconciled with majoritarian democracy. Now, there is a proposal, the National Popular Vote Compact, where states would enter into a compact that they would promise to give their electoral votes to the candidate that wins the popular vote. But it would take some of the red states to go along, and so far they haven't. Also, I'm not sure it's constitutional in terms of the compact power, and I don't know how it could be enforced. And so that's the only solution that I've seen, because a constitutional amendment just isn't realistic.
Rick, what is your take on this?
I agree with Erwin, and I'm very skeptical of the National Popular Vote Compact. And I'll give you one example of why. So the compact itself says that it comes into effect once enough states representing a majority of Electoral College votes ratifies it. And we're pretty close, but not quite there yet. Suppose that you have an election that's kind of like Trump and Biden or Trump and Clinton. It's very close, but it looks like in a big state like, say, California, that the voters are going to favor Biden, but the country's going to favor Trump on the national popular vote. You can imagine that California tries to pull out of the compact at the last minute. Even though the compact says you can't pull out in the last 6 months before the election, Article 2 of the Constitution says the state legislatures get to set the manner for picking presidential electors. So I don't see how the compact could trump that power. And so it seems to me that, we would just be setting ourselves up for yet another crisis. And I don't think we want that. So I'm, as much as I think we should decide our elections by the popular vote, and I think for purposes of democracy, it's a problem when you have such a disparity between Electoral College outcomes and popular vote outcomes. I don't see an easy way out of it. I'll point out also, thought it was interesting, Jeffrey Rosen of the National Constitution Center just published a piece yesterday in The Atlantic. They got conservatives, libertarians, and progressives to try to draft their own constitutions. How would you rewrite the Constitution today? And all of them agreed on getting rid of the of the Electoral College in favor of a national popular vote, which is kind of an interesting experiment there.
The problem is what else they agreed or disagreed on if we ever had another constitutional convention. Right. Let's return to that fundamental question of the future of voting and democracy in this country. I think historians will look back on this period that in the midst of a pandemic, we had an extraordinary turnout of people. We had absentee voting, online registration. We had a prolonged voting period. We now have an election season rather than an election day. It was really a high note for democratic participation in elections. But then we have seen, Erwin cited what I have in my notes, that even 70 to 80% of Republicans believe the election was stolen. We are seeing that manifest itself across the board in different protests and reactions to this election. On balance, Erwin, to start, will we look back and even most recently next year and before the midterms, has this period helped or hurt American democracy?
I think it's helped American democracy. You point out the tremendous turnout in this election in the midst of a pandemic. Also, I think we've got to talk about how there's no evidence of significant fraud in this election. There was every effort to try to find it, but the kind of things they were talking about were almost laughable. That Hugo Chavez, who died 6 years ago in Venezuela, was somehow controlling the outcome of this election. That there were mysterious trucks of fake ballots going around. You only had to listen to what was said, and it sounded like a Saturday Night Live skit in itself, that we were able to conduct this election without significant fraud as a triumph of election. But the other thing that I would say is this is a place where the guardrails that exist for democracy really worked. The election officials in places like Georgia counted the votes honestly and accurately, even though they faced personal threats and repudiation from the president. The political officials, I mean, I'm no fan of Governor Kemp of Georgia, but the president called him and pressured him to try to change the result, and he refused to do so. The courts have really come through, both Democratic appointed judges and Republican appointed judges. They followed the law. These are the guardrails of democracy, and they worked. And so I would say overall, this election has been a real triumph for democracy.
What's your take on this, Rick?
I'm glad I can finally disagree with Erwin about something. I'm just upset that it's about this because it matters so much. I think that election administrators and the country did a tremendous job getting out the vote and making it safe for people to vote, even in the midst of the pandemic, even in this very difficult time for the United States. And I agree with Erwin that the guardrails held, but they barely held. You know, I think we're careening around a curve and we're hitting up against that guardrail. And it wouldn't have taken much more force for us to go over. If the election were 8,000 votes closer in Georgia and in Arizona, so 16,000 different votes, I think that we would be in the midst of a national crisis. And I think that we would be at a place where you would see state legislators convening, you'd see people in the streets. It would be extremely ugly. And it's very hard to know what Trumpism means after this election, whether Trump fades from view. He's certainly not going to try to fade from view. How much of a commitment to the rule of law you'll see, because for every Brian Kemp, who, you know, Brian, I've been very critical of Brian Kemp in my writing, for every Brian Kemp, and he should get kudos for standing up to Trump, there were others who didn't stand up to Trump. Mitch McConnell, I think, bears a tremendous amount of responsibility here. Now, the kind of the best case scenario is he's putting his head down and trying to weather the storm, and he actually does believe in democracy. But I think there are a significant number of Republican leaders around the country who were willing to take and are willing to take an authoritarian gambit and actually take the election away from the American people. And that's really scary. And I'm worried about our future with so many people going along with the nonsense that we've seen come.
I actually don't think we disagree, Rick. I think we were just pointing to different things. I agree with everything you just said. I pointed to the things that I think went well, because this wasn't an election where there was evidence of significant foreign interference, and many feared it. There wasn't evidence of significant voter fraud. The elected officials, the election officials who were running the elections, the courts, all did come through, though everything you say in terms of concern for the future is absolutely right.
There's a question which relates to this, to expand these thoughts, of why have elected officials been playing or going along with Trump's refusal to accept certified election results? Why haven't we seen more forthright and courageous statements, both rejecting election fraud, supporting what the evidence has shown? What is going on in this country when it comes to elected officials? And to put it on the table and maybe previewing your book, Rick, what is going on in the populace and in the sources of information they are receiving and the echo chambers that Americans live in today that has allowed the notion that this is a stolen election to gain so much traction?
Yeah, I mean, I think a big part of this, and this is really in the realm of political science and no longer law. I think a big part of this is that we're in the midst of a realignment of the political parties, where the Republican Party is on its way, kind of like the way the Tea Party was pushing towards becoming a a right-wing populist anti-immigrant type of party, certainly a white rural-based party. And a lot of this is motivated by fear of the future and what a multicultural America would look like. And in this era of cheap speech, and that's the name of the book I'm working on now, Cheap Speech, in this era of cheap speech where it's so easy to spread disinformation, what I think we see is that there are people on the right, like Trump, who can use social media to directly reach millions of people and put forward a message that goes against all of the norms that constrain power. The courts, the press, universities, the opposition political party, in a calculated way of trying to actually wrest power in an anti-democratic way. And I think this is really the question for our times, is what's that going to look like, 5 or 10 years from now? Is that part of the party going to be able to remain in power as an increasingly minoritarian party?
Erwin, as we come to a close, your thoughts in response to Rick just now, but I'd ask you to frame them in the context. We have almost 200 people joining us today, law students, lawyers, others who are deeply concerned about this. What can they do about this as you give us your closing thoughts?
I obviously agree with what Rick just said. I'd answer your earlier question by saying some of what we're seeing is the power of Trump in the Republican Party. Politicians are unwilling to challenge him because they fear that they'll then be vulnerable to a challenge from the right. And that craven political calculation has become more important than the standing up for democracy. Also, I think there are some who aren't committed to democracy. That I think in any society, there are those who would favor authoritarian rule. And some of the opinion polls about a lack of commitment to democratic principles are very frightening to me for the future. I think the key is to get involved. And my hope is that people will get involved in making our electoral system even better before the midterm or the next presidential election. We've seen an expansion of absentee ballots. I think we need to go more in that direction. I think we've seen a lot of flaws that exist in state electoral systems. I think we need to work to remedy those flaws. We need to make sure that we are secure from foreign interference with regard to our election system. So there's a lot of work to be done. I think the way we do that is by getting involved and getting involved with the organizations that are doing that work.
Rick, your concluding thoughts.
Well, I think we're at a crossroads, and as I mentioned a few minutes ago, it's a question of which direction we're going to go, and it's going to take more than it will take some legal change, and lawyers have a role to play, but it really is a question about civil society and strengthening the norms of the rule of law, respect for science, and respect for truth, and that's really the big challenge for our time going forward.
Thank you both. We've gotten a lot of truth today, and I can tell from the comments and the Q&As how much people have appreciated this program. The out-of-court programs of the Beverly Hills Bar Association will continue next year in 2021, and lawyers on this call will be getting notices and information about that. I can only echo what both of our excellent guests have said. Which is you cannot sit on your hands. You cannot sit back and complain. You've got to take an interest. You have to be the people on those local voting boards and doing the hard work of being active in this democracy, keeping it fair, keeping it honest, and keeping it just. Thank you very much for being with us today. Thank you, Erwin. Thank you, Rick, so much. And everyone else, please be safe. Thank you.
Take care.